Good afternoon. Welcome back to Passionate World Talk Radio Network. PWTRN is a wholly owned subsidiary of Global Media Network, LLC. Educate, enlighten, entertain. And on today's episode, this is a continuation of the First Amendment, the Supreme Court, and a potential Republican candidate running for President of the United States. We're going to start off with speaking about there are two competing visions of what free speech is and what it means. Chief Justice Fred Vinson wrote in 1951, Dennis versus the United States, quote, "No important case involving free speech was decided by this court prior to Schneck versus the United States in 1919. Schneck, moreover, offered no hints that Americans would one day live in a nation where art, literature, and political speech all enjoyed robust constitutional protection. It unanimously upheld the convictions of men who distributed anti-draft literature to conscripts. However, the court's earliest First Amendment case was a disaster for the cause of free speech in the early 20th century when Justice Oliver Wendell Holmes developed a framework of dissenting opinions about the First Amendment and First Amendment law to today. The government must not interfere in what Holmes referred to as, quote, free trade in ideas, unquote. Meanwhile, private companies, including newspapers, Hollywood studios, and newer forms of media, say, for example, Facebook, would remain free to say what they want and to shun whichever ideas they chose. The reason for this focus on government regulation of speech is really quite simple. The state has a monopoly on the legitimate use of force and can use the monopoly to crush dissenting voices. In Holmes' words, to, quote, sweep away all opposition, unquote. Private speakers may be powerful and influential, but they cannot suppress their opposition. If you don't like what you read in the New York Times, you can then go and subscribe to the Wall Street Journal. If you don't like a co-worker's ideas, you are under no obligation to invite them into your home. If that co-worker is up for a promotion, their boss is under no obligation to promote them if they also find their ideas abhorrent. Only the government is constrained by the First Amendment because only the government can arrest, detain, or execute someone for speaking out of turn. And the First Amendment generally prohibits the government from interfering with Holmes' marketplace of ideas. Then there are the net choice cases who sought to upend this vision. The Florida and Texas laws at issues in these cases were an explicit attempt to use the government to elevate conservative voices. The law's proponents were quite open about this fact, as Texas Republican Governor Greg Abbott said of his state law, it was enacted to squash a supposedly dangerous movement by social media companies to silence conservative viewpoints and ideas. Under this emerging Republican version of the First Amendment, the government may manipulate the marketplace of ideas whenever it determines that one side's ideas aren't receiving a big enough platform. These laws are at issue in net choice, which are quite ham-handed, but they were written to give the impression that they were attempts to protect free speech. Texas law, for example, forbade the major social media platforms from removing or downgrading content because of the, quote, viewpoint, unquote, expressed in that content. It also imposed very strict reporting requirements on the platforms and required them to set up a rapid process that will allow users to appeal removal of content. Now, 2 weeks ago, the potential Republican candidate for president, Mr. Trump, said that people who disagreed with the Supreme Court's ruling on any case should be in prison for a long time. In other words, have their freedom of speech taken away. According to what I'm telling you, these requirements just weren't unconstitutional under long-standing court decisions establishing that the government cannot tell media companies what they must print, meaning that a potential presidential candidate cannot tell citizens of the U.S. that they should be thrown into prison because they disagree with what the Supreme Court rules. It's the highest law of the land, not prohibiting you from speaking one's mind. If YouTube cannot engage in viewpoint discrimination, for example, that means that it cannot remove a video posted by a literal Nazi who calls for the extermination of all Jews, unless it also removes all content that takes the position that Jewish people should not be exterminated. This sort of requirement wouldn't simply destroy the broadly inclusive communities many social media companies hope to create, it would also destroy their business models. As The Verge's Nilay Patel colorfully explained, running a profitable social media company, quote, means you have to ban racism, sexism, transphobia, and all kinds of other speech that's totally legal in the United States, but reveals people to be total assholes, unquote. That's because advertisers don't want their ads to appear next to a burning cross or a swastika. And if this kind of content is not banned, advertisers will flee the platform, as they did when the social media site formerly known as Twitter loosened its content policy. Also, the Texas law owning its requirements would have required the platforms to hire a small army of employees. In a brief challenging the Texas law, the social media industry complained that YouTube alone would need to expand its current appeal system capacity by over 100 times, from a volume handling millions of removals to that of over 1 billion removals. That's the kind of hiring mandate that is likely to shut down a company. In its zeal to prevent social media platforms from banning some right-wing voices, Texas managed to draft a law that could have shut down an entire industry, totally eliminating the ability of social media users to engage in free trade in ideas. The First Amendment quite obviously cannot tolerate such a law. 2 justices would allow red states to shut down newspapers with malicious lawsuits. Thomas and Gorsuch, meanwhile, have far less subtle plan to roll back press freedom. Indeed, under their approach to the First Amendment, authoritarian state governments could quite easily shut down nearly any media outlet. Reminiscent of the potential Republican candidate, only time will tell. In the 1960s, the New York Times published a full-page advertisement paid for by civil rights activists, which sought to raise money for the struggle for the right to vote in the Jim Crow South and to pay for legal representation for Dr. Martin Luther King Jr. Unfortunately, though, the ad contained a few minor factual errors, such as misidentifying the song sung by student protesters at a particular protest. They sung the Star-Spangled Banner and not My Country 'Tis of Thee, and overstating the number of times Dr. King had been arrested. He had been arrested 4 times, not 7. Pointing to these small errors, a Montgomery police commissioner filed a defamation suit against the Times, and Alabama's courts awarded him $500,000, more than $5 million in 2024 dollars. That decision eventually came before the Supreme Court in the aforementioned New York Times versus Sullivan, which recognized that, quote, erroneous statement is ineffable and free debate, and that it must be protected if the freedoms of expression are to have the breathing space that they need to survive. If media outlets could be hit with such expensive verdicts because of honest and regrettable mistakes, freedom of the press cannot exist, because every reporter will occasionally make a factual error similar to the ones at issue in Sullivan. Accordingly, Sullivan ruled that at least when someone makes a statement about a public figure regarding a matter of public concern, they cannot be sued for defamation unless they knew they made a false statement or they acted with reckless disregard for the truth. Broadly, Sullivan stands for the proposition that state governments cannot use defamation law to maliciously target the press. If a reporter makes a serious error, that reporter may still be liable for defamation. But governments that want to shut down a newspaper cannot simply wait until a reporter misremembers which song was sung at a rally and then pounce with a multi-million-dollar lawsuit. Trump, Thomas, and Gorsuch, however, have all called for Sullivan to be overruled. In a 2022 legal filing, Trump made the ahistorical argument that Sullivan should be abandoned because it seems unlikely that when the court handed that decision down in 1964, it envisioned a news outlet which seeked to indoctrinate its audience rather than inform. In reality, though, the partisan press has been part of the American landscape from the very beginning. One early American newspaper falsely and racistly labeled then presidential candidate Thomas Jefferson, quote, the son of a half-breed Indian squaw sired by a Virginia mulatto father, unquote. Meanwhile, dissenting in Berkshire versus Lawson in 2021, Gorsuch suggested that defamation law should be almost exclusively the business of state courts and legislatures. Had Gorsuch's view in Berkshire prevailed, it would have allowed Alabama to target civil rights activists in exactly the same way they were targeted in the Sullivan case. And it would potentially allow Donald Trump to seek millions of dollars in damages from any reporter or news outlet that makes even a tiny error in a report about him. It's too bad you can't say and sue Mr. Trump for when he makes his tiny errors. So, how worried should we be about the future of free speech if potential Republican candidate Trump wins? Looming over all of this is the Federalist Society, the powerful association of right-leaning and far-right lawyers that play an enormous role in selecting Trump's first-term judges, and that is likely to play a similar role in any future Republican administration. For many years, the legal right embraced the Holmesian view of the First Amendment. If anything, Republican lawyers and judges tended to view the First Amendment even more expansively than their Democratic counterparts because they often use the First Amendment to attack campaign finance laws. Since Trump has left office, however, many of the Federalist Society's conferences and events have descended into increasingly paranoid complaint sessions about cancel culture and wokeness. In 2022, the Society's annual Lawyers' Convention featured no less than 4 panels complaining about the fact that Federalist Society members sometimes feel unwelcome at law schools and in various institutions within the legal profession due to their conservative views. Federalist Society speakers warn, in the words of lawyer Ashley Keller at a 2021 event, that, quote, massive corporations are pursuing a common and mutually agreed upon agenda to destroy American freedom. Or, as law professor Adam Kandavob claimed that same year, that it is inevitable that members of the society will be deplatformed. And the society appears eager to use the power of government to ward off this imagined failure. At the 2021 gathering, speakers offered policy proposals ranging from legislation like Texas and Florida's unconstitutional social media laws to repealing bans on rice and sex discrimination to a vague and disturbing plan to, quote, weld in state legislative chambers some degree of power to punish our enemies within the confines of the rule of the law. Let's not forget the potential candidate Trump has threatened to punish his enemies when he becomes president. Think about that. So, while Thomas, Alito, and Gorsuch do not currently have a majority on the Supreme Court to roll back the First Amendment freedoms, momentum is very much on their side, at least within the elite GOP circles. Republicans ranging from Trump to the legislatures of many red states and the organization most responsible for the judges that Trump has put in have all turned away from the Holmesian vision of the First Amendment and toward one where the government plays a much larger role in deciding who is allowed to speak and what media outlets must publish. Visions of Adolf Hitler. And other subsequent dictators. We can no longer be known as the United States of America, a country of democracy. Think about that. Oh, I know. I have a lot of good friends who are Republicans, and they think I'm crazy. But I'm not so sure. We were given the right of freedom in the 1960s, but it's hardly been recognized since then. It just depends who's in power and who's in control. And as I kindly tell people, there can only be one king on that mountain at all times. And unless that person abdicates or is overthrown by a coup d'etat, they are the ruling power. As a net choice case shows, they may even include using the power of government to order media outlets to publish content that aligns with the government's political opinions. Nazi Germany, anybody? Stalin's Russia? Putin's Russia? Cuba under Castro? I remember my history. I'm the product of the 1950s. And we were taught about World War I and World War II most thoroughly. And I carry it with me to this day, as does my son and his children. Something to ponder. All of this analysis, however, comes with caveats. If Trump wins, he may not get to replace any members of the Supreme Court, or he may only get to replace some of his allies who dissented in that choice, though he's all but certain to replace hundreds of lower court judges if elected president. In the American system, where justices serve until they retire or die, no one can be sure how much power each president will have to reshape or, as he has said, get rid of the Constitution. Still, a vote for Trump is a vote to roll the dice on a drastically different version of free speech in the United States. I mean, we use that all the time. We have the right to say whatever we want, whenever you want. Well, November's fast approaching. Think about that. And the lack of free speech is one that bears far more resemblance to the not-so-distant past than it does anything most modern-day Americans have experienced. So, ladies and gentlemen, something for you to think about. And if you don't want to think about it, just remember this. History repeats itself because it's never remembered for not resolving the problems when they first appear. Thank you very much for listening. Lest We Forget Historical was brought to you by two companies. The first one is myflex.ruby.ai, and it is an artificial intelligent program all into one. It's approachable, innovative, and it's one-stop shopping. Go try it out at https://myflex.ai/ESC73. Sign up for one of the monthly subscriptions, $35, $55, $100. And then text me 484-364-1032 and ask for a pain point sample to be done in Ruby's AI demo, and be happy that you did. And who am I? Lillian Cauldwell. The second company is brought to you by PWR Talk Radio Network, the obstacle training course for podcasters. Whether you're a middle school, high school, college, junior college, charter school, private school, homeschool, beginner, intermediate, expert, learn how to be a better podcaster or use your skills, communication, with what you're doing with your life, your business, and with your peers. Go over to https://education.passionateworldtalkradio.com to see this podcast all over again. Go over to youtube.com/@passionateworldradio or over to our website, https://passionateworldtalkradio.com/blog, and listen to the audio. Have a great weekend and join us next Friday at 3 o'clock. Thank you.